Okay, we welcome everyone to the the CCMW uh, knowledge sharing workshop, and we're going to start with the land acknowledgement. And so Ontario, first with the land acknowledgement for Ontario. Ontario is covered by 46 treaties and other agreements, such as land purchases by Crown signed between 1781 and 1930. Treaties are the legally binding agreements that set out the rights, responsibilities, and relationships of First Nations and the federal and provincial governments. The goal of this is to encourage the acknowledgement of the First Peoples on whose traditional territories we live and work. Acknowledging territory shows recognition of and respect for Aboriginal peoples. It is recognition of their presence both in the past and the present. Recognition and respect are essential elements of establishing healthy reciprocal relations. These relationships are the key to reconciliation. However, acknowledging territory is only the beginning of cultivating strong relationships with Canada's First Peoples. We encourage our affiliates to reach out to local Aboriginal communities to open pathways for dialogue. We will continue to be an active partner with our Indigenous allies across Canada, supporting their crucial work on the issue of missing and murdered Indigenous women and girls, environmental degradation due to resource development policies, and the need for major public investments in Indigenous education, healthcare, social services, water infrastructure, and housing. We begin this meeting also from Niagara by acknowledging the land on which we gather in the traditional territory of Haudenosaunee and Anishinaabe peoples, many of whom continue to live and work here today. This territory is covered by the Upper Canada treaties and is within the land protected by the Dish with One Spoon Wampum Agreement. Today, this gathering place is home to many First Nations, Métis, and Inuit peoples, and acknowledging reminds us that our great standard of living is directly related to the resources and friendship of Indigenous people. We would like to also acknowledge in the Mississaugas, the Peel region, for Mississauga and Brampton, the land on which we gather and which the region of Peel operates is part of the treaty lands and territory of Mississaugas of the Credit. For thousands of years, Indigenous people inhabited and cared for this land. In particular, we acknowledge the territory of Anishinaabe, Huron-Wendat, Haudenosaunee, and Ojibwe, Chippewa people, the land that is home to the Métis, and most recently the territory of the Mississaugas of the Credit First Nation, who are direct descendants of the Mississaugas of the Credit. We are grateful to have the opportunity to work on this land and by doing so give our respect to its first inhabitants. Thank you. Soraya, you can start the opening remarks.
Welcome to CCMW, Brampton-Mississauga, and Niagara Know Your Rights Knowledge Sharing Workshop. I'm Soraya Khalili, Chapter President for Brampton-Mississauga, and on behalf of CCMW, I welcome you all to the Knowledge Sharing Workshop. Thank you for registering and being here. Today, you will get an overview and an introduction to the larger content of the 7 webinars that were held in June of this year and which explore specific family law issues in detail. These will be made available to you virtually in both official languages. In addition to the webinars, 6 brochures were produced by CCMW that also provide the same comparative information about Canadian and Muslim family laws as they pertain to women's legal rights. These are also available to you online, and if you wish printed copies, please indicate in the chat box, and we will do our best to get them to you. The topics are marriage, divorce, custody and child support, family property and spousal support, domestic contracts, and inheritance. The CCMW is an equality-seeking national women's organization, and this project aims to empower Canadian women, Muslim women in their ability to make informed choices in the area of family law and legal rights in Canada. Shanza, please go ahead.
Thank you, Soraya.
You're welcome.
Thank you for taking time out to join us today. My name is Shanza Khan, Chapter President for CCMW Niagara. Before we begin the workshop, let's go through some housekeeping rules. Today's workshop is being recorded. The recording of this workshop will be available afterwards on our website. You can actually go to www.ccmw.com/Brampton-Mississauga and www.ccmw.com/Niagara. We welcome you to revisit the content yourself and share it with your networks. Please ensure your video camera and microphone are muted during the workshop. This will help eliminate ambient noise and increase clarity. We invite your comments and questions and will run 2 live Q&A sessions during the first half and at the end of the workshop using the chat box. The chat box button is the 6th button from the left at the bottom of your screen. Once you click it, the chat box will appear on the right-hand side of your screen. If you think of a question at any point, just type it in the chat box and we will pose it during the Q&A portion. You could choose to ask the question anonymously by sending the message to Sabrine or Zainab, the hosts, as opposed to everyone. An evaluation will be emailed to you later today, and we will be also posting the link on the chat box. It will take about 5 minutes to complete. Please don't include your name on this form in order to maintain your anonymous status. The information you provide will be kept confidential and private. Only authorized individuals at CCMW will have access. If you require any technological assistance, please send us a direct message using the chat box or text Sabrine at 416-897-1907. I pass this to Soraya now. Thank you.
Thank you, Shanza. The vision and mission of CCMW. The Canadian Council of Muslim Women, CCMW, is a national non-profit organization committed to attaining equality, equity, and empowerment for all Muslim women in Canada. Founded in 1982, the organization works to promote Muslim women's identity in the Canadian context. For more than 37 years, CCMW has proudly advocated on behalf of Muslim women and their families and developed national projects that enrich the identity of Canadian Muslims, encourage civic engagement, and empower communities. During the past several years, the Canadian Council of Muslim Women has undertaken initiatives to inform Muslim women, the legal profession, community service agencies, policymakers, and the general public about the differences between Muslim family laws and Canadian family laws. Previously, CCMW published Muslim and Canadian Family Laws, a comparative primer in English and French, and a series of booklets in several languages on family law topics to further its public education efforts. Our latest project in this field, Muslim Women's Family Law and Legal Rights, is updating these documents and disseminating them via knowledge-sharing workshops within different cities across Canada for Muslim women, community service providers, the legal profession, and the general public. In 2003, CCMW took the lead in establishing Coalition Against Religious Arbitration, composed of about 50 sister organizations, including the National Association of Women and the Law, NAWL, METRAC and the YMCA, the No Religious Arbitration Movement, and CCMW's work represented an array of complex issues and events. We were successful in that the Government of Ontario made a decision to disallow the use of religious family laws under the province's Arbitration Act. CCMW advocated for one set of laws to be applied to all, regardless of faith, ethnicity, race, or culture, under the existing family law legislation. CCMW believed that the use of religious laws through private arbitration to settle family matters under the Arbitration Act violated the hard-won equality rights guaranteed under the Canadian Charter of Rights and Freedoms and had the potential of creating a two-tiered, fractured justice system. CCMW was compelled to inform Muslim women about the choices they have available to them within Muslim and Canadian family laws and simultaneously educate individuals and institutions that assist them or work with them to resolve family disputes. CCMW is composed of a national board that works to further CCMW's objectives at a national level and 17 local chapters made up of members whose passion and hard work advance the vision of CCMW within local communities. To learn more about CCMW, visit www.ccmw.com. Thank you so much. Shanza?
Thank you, Soraya. I would now like to introduce the fellow facilitators. Glenda Perry. We are honored to have Glenda Perry, family lawyer, with us today. She graduated from Osgood Hall Law School in 1990. She has been practicing family law since 1992. Her practice involves cases that are litigated in court, as well as cases that are resolved through negotiation, mediation. Many of the cases that are referred to her involve complex parenting issues, intimate partner violence issues, and jurisdictional issues. Before we continue with introducing other facilitators, I also would like to pay tribute to Justice Ruth Bader Ginsburg, who passed away on September 18. We're deeply saddened by the passing of Ruth Bader, champion of gender equality and a legal, cultural, and feminist icon, and an admirable leader for women, equality, equity, diversity, inclusion, and justice. May we continue to fight with the same strength, tenacity, and courage as she did. So going on with Sitara Sheikh, the previous president of Brampton-Mississauga chapter, who worked as a family counselor for several years and for a child protection agency for about 20 years. She's currently working as a consultant in the area of child protection services and delivering workshops in emerging countries, including Pakistan, about how to prevent child abuse. Sitara is a fierce advocate for women's and children's rights, tirelessly working towards creating an equitable society free of oppression and racism, and by being involved with different agencies, including CCMW.
Shanza Khan is the president of the Niagara chapter of CCMW. She has a master's in educational leadership and administration from Brock University. She dedicates her efforts to empowering women and girls, as well as empowering victims of domestic violence, gender-based violence, and any violence and torture survivors through advocacy, education, mentorship, support, social, and economic empowerment.
Thank you, Soraya. And I'm now also going to introduce Soraya Khalivi, is the president of the Brampton-Mississauga chapter. She is a social service worker and a violence against women counselor. She is passionate about what she does, supporting and empowering women in abusive situations. Part of her portfolio includes running information, sharing programs for men, and facilitating workshops on senior abuse. I will also be talking about evaluations. Thank you in advance for completing the evaluation that I mentioned earlier regarding your experience in participating in the Canadian Council of Muslim Women's Virtual Knowledge Sharing Workshop. The link for the evaluation can be found in the chat box and will also be emailed to you later today. Thank you.
My name is Sitara Sheikh, and thank you everyone for joining us today. So we are going to cover 6 brochures. The 6 brochures are marriage, divorce, custody and child support, family property and spousal support, domestic contracts, and inheritance. Next slide, please. And the information in those 6 brochures is based on Muslim and Canadian family laws, a comparative primer that was published by the Canadian Council of Muslim Women in 2006. Next, please. So I'm going to talk briefly about the goals for today's webinar. The main goal is to assist Canadian Muslim women to make informed choices in the area of family law in Canada and to address the ongoing and urgent need of Canadian Muslim women to understand their rights under Canadian family laws. And we hope that this webinar will assist professionals, students, young Muslim women, and community-based service providers involved in providing legal information to Muslim women facing family law issues. We will use a scenario for the discussion in 6 areas that we have already talked about. So before we start the discussion, please note that the information contained in this webinar is just that, information. It's not legal advice and should not be interpreted as such. If you or someone you know is dealing with a family law issue, it's important to meet with a lawyer to discuss the situation and to receive legal advice. The webinars, the brochures, and the primer are not a replacement for legal advice. So we have a family law lawyer here today who is going to answer the legal questions, but please make a note that this is not legal advice. And if you would like to find out more about the sources and validity of Muslim laws and legal opinions referred to in this workshop, you should consult Muslim and Canadian Family Laws, a comparative primer. Also, we have to remember that laws and public legal systems are in a constant state of flux as they are changed to adapt to the times. What you hear in this workshop today and what you read in the brochures is accurate to the date of publication. So you are encouraged to verify that the information contained in the documents about Canadian laws is current to the time you are reading or hearing it. So Shanza is going to talk about the Canadian laws now. So Shanza.
Thank you, Sitara. So I will be talking about the Canadian laws. And just as Sitara mentioned, that it is not a legal advice, it's just for information. So in Canada, the Canadian Charter of Rights and Freedoms specifically addresses equality rights of women. Canada is also a signatory of the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, and the International Covenant on Civil and Political Rights, ICCPR. Both these documents provide equality rights protection for women, which take precedence over the right to religious freedom. In Canada, we also have case law. Case law or court decisions further addresses the issue of women's rights. Public court decisions are required to conform with the Canadian Charter of Rights and Freedoms. Court decisions are a matter of public record and can be appealed to a higher court. Family law, that is the main goal of our workshop today. So family matters are governed by a number of federal and provincial laws. Some matters relating to marriage, such as rules about who can marry whom, are a federal responsibility. Others, such as the technical administration of marriage, are provincial. Divorce is regulated federally under the Divorce Act, which underwent substantial revisions in 2019 to come into effect in 2020. Provincial laws cover custody, access, child support, property division, spousal support, restraining orders, and child protection. Inheritance is also a matter of provincial regulation. The names of the statutes vary from province to province, but the general issues covered are the same. And the overall approach is similar, although there are regional differences. These laws exist to assist families and to provide minimum common standards across the country. We have the next slide. The access to justice and legal aid. Everyone involved in a family law matter can use the services of a lawyer to support and assist them in an attempt to ensure that people without the financial ability to pay for their own lawyer can still be properly represented. And the provinces have developed legal aid plans. For example, in Ontario, the legal aid plan is called Legal Aid Ontario, LAO. Ontario's model provides successful applicants with a certificate for coverage, and the people selects their own lawyer. The financial criteria in Ontario are very limited. Eligibility is determined by a review of the person's income and expenses. LAO sets different financial criteria for victims of domestic violence to make it easier for them to qualify for assistance. Legal Aid Ontario primarily covers representation for court-based matters. there is very little legal aid available in private dispute resolution cases. In regards to the private dispute resolution, many people prefer to resolve the issues arising from the end of the relationship outside the court system. However, in situations where there is an unequal balance of power, private resolutions may not reflect either the legal rights or the interests of the persons with less power. Family law disputes are privately resolved through either mediation, arbitration, or collaboration law. Ontario's Arbitration Act requires that all family law arbitration be conducted exclusively in accordance with the law of Ontario or another Canadian jurisdiction. Arbitration conducted under any other system of law, including religious law, is not considered family arbitration and is not enforceable in Ontario courts. There are differences between arbitration and mediation. Arbitration is quite different from mediation in that the arbitrator, after listening to what each party has to say, will announce a decision, much as a judge does in the case. The parties are bound to accept this decision. In fact, they have agreed to this before beginning the process. In mediation, the mediator assists the two people come to an agreement about issues that are in dispute. Both mediated settlements and arbitral awards can be enforced by the court. The changes in arbitration law do not interfere with the right of individuals to go to elders and religious institutions for advice and counseling, but these processes will only be sanctioned by the state and be legally binding if the family law of Canada is used. The Canadian legal system. The Canadian legal system is a public legal system with laws and systems in place that are intended to ensure women's equality rights. Under this system, laws are open to public review and scrutiny, and court decisions are a matter of public record. Moreover, the decisions can be appealed to higher courts. In Canada, anyone involved in court proceedings has the right to have a lawyer represent them. For those who cannot afford legal representation, government-funded legal aid is available. A public law system supports a consistent approach and some measure of equality and accountability. Even so, the public system of law is not perfect. Private rules, including religious laws, do not offer these same protections. They are not open to public review and scrutiny, and those who interpret them are not accountable to the public in any way. There is often no right of appeal from a bad decision made under a private regime. There is not necessarily a right to legal representation, and legal aid is seldom available. So for these reasons alone, a public system of family law is to be preferred over a private one.
And I'm going to be talking about Muslim law and Sharia. While the Quran and the Sunnah of the Prophet contain some injunctions on how to act in a number of circumstances, virtually all of the substantive body of Muslim law was developed by self-governing scholars over the course of many centuries. The body of practical rules developed by the scholars came to be known as fiqh, which literally means knowledge. So Sharia is the divine revelation. It's the fundamental source as represented in the Quran and the Sunnah. And other sources of law in the Sunni tradition include the consensus of the community, and in the Shia tradition, the pronouncements of the imams are also considered authoritative. Next slide. I also would like to say that fiqh is the best guess of the community of jurists at any given point in time, and does not claim for itself any sort of objective truth or identity with divine will. Much can be written about the legal institutions and practices, but for our purposes of understanding the applicability of Muslim family laws in Canada, it is sufficient to acknowledge the variations found within these laws, and that is fiqh. So fiqh is man-made rulings that constitute the body of Muslim law, and Sharia, the ideal way of living in an ordered community, which is through according to divine justice. Next slide, please. Now, Muslims commonly follow the opinions of the jurists. This is predicated on the assumption that those jurists are learned and wise, and not because of any inherent obligation to follow authority. Muslim women are under no obligation to follow the legal opinions of any particular school of law, let alone any specific jurists in matters pertaining to family law. In fact, being free to choose among the variety of opinions offered by the schools of law, a concept referred to as takhayyur has always been a central feature of Sharia as a system of justice. So the Quran includes some verses with rules about family laws, but most Muslim family laws are part of man-made fiqh. That's, thank you. The next slide. Zainab. Thank you. We can move on to the next slide, Zainab. Thank you.
Okay, thank you, Soraya. We will be now doing the scenario video. And before we have the video played, I will do the disclaimer. The scenario script and scenario video are owned by the Canadian Council of Muslim Women, CCMW, and cannot be recorded, reproduced, or distributed. The scenario is completely fictional, with the sole purpose of anchoring participants in interactive discussions to engage with workshop materials. The CCMW is vigilant of racial, gender, and religious stereotypes used against and within Muslim communities, and strictly disallows the scenario script and video to be used to perpetuate the very stereotypes we strive against. For this reason, both the scenario script and scenario video are prohibited from being accessed beyond the scope of this workshop.
Yusuf and Aisha were married in Malaysia in 2002. Their marriage was arranged and they did not know each other very well. They were married in an Islamic ceremony and agreed on a mahr amount of $10,000, with $5,000 to be paid immediately and the remainder deferred. The couple's first daughter, Maha, was born in Malaysia. They moved to Canada when she was 2 years old. Since then, they have lived in Quebec and Alberta. They moved to Ontario in July 2018. Their other two children were born in Canada, their son Rehan and their youngest daughter Hannah. Their marriage has been very difficult since they moved to the country. Yusuf does not understand or accept the rights that women in Canada have, and Aisha would like more independence and freedom. Yusuf makes good money working as an engineer. Aisha has been at home with the kids, but would like to go to work, now that their children are in school full-time. Yusuf does not want Aisha to work and has become even more controlling of her. They live in a house that is registered in his name alone, and all the bank accounts are in just his name. He provides Aisha with a monthly allowance. While Aisha is the primary parent of the household, Yusuf is the disciplinarian, and he can be quite strict. He uses corporal punishment with the children, which Aisha does not agree with. There are also many tensions between Aisha and Yusuf about their 15-year-old daughter, Maha. She wants to go out with her friends and go to parties, but her father will not permit this. He also wants Maha to dress more modestly, but she wants to dress just like her friends.
So thank you, Shanza. Oh. So Shanza, thank you very much for reading the disclaimer. I'm going to read the scenario now.
Can you just hang on, Sitara? Because I think that the video has to play in its entirety, and then you come back to the different pieces of the scenario, I believe. So I think it's still playing, but we can't hear it anymore.
Yusuf to protect her daughter, but she wants to know what her rights and responsibilities would be, and whether she would have enough money to support herself and the children. One day, Aisha receives the shocking news that Yusuf has suddenly died at work. Neither Yusuf nor Aisha has a will. Aisha knows very little about the family's financial situation. She knows there's a lot of jewelry in a safe in Yusuf's home office, but she does not know the combination to get into it. She doesn't know where they bank, how much money is in their accounts, or how much money they owe on the house. Yusuf mentioned a few years ago that he inherited several $100,000 when his father died, but Aisha does not know what he's done with this money.
So next slide, please. So you've seen the video now, and I'm going to read the scenario. Yusuf is 40 years old, Aisha 38 years old, Maha is 15, Rehan 10, and Hannah is 7 years old. Yusuf and Aisha were married in Malaysia in 2002. It was an arranged marriage, and they did not know one another very well. They were married in an Islamic ceremony and agreed on a mahr amount $10,000, with $5,000 to be paid at the time of the marriage, and the remainder was deferred. Their first daughter, Maha, was born in Malaysia. They moved to Canada when she was 2 years old. Since coming to Canada, they have lived in Quebec and Alberta. They moved to Ontario in July 2018. Their marriage has been very difficult since they came to Canada. Yusuf does not understand or accept the rights that women in Canada have, and Aisha would like more independence and freedom. Yusuf works as an engineer, making good money. Aisha has been at home with the children, but would like to work outside the home now that the children are all in school full-time. Yusuf does not want Aisha to work and has become even more controlling of her. They live in a house that is registered in his name alone, and all the bank accounts are in just his name. He provides Aisha with a monthly allowance. Aisha is the primary parent, but Yusuf is the disciplinarian, and he can be quite strict. He uses corporal punishment with the children, which Aisha does not agree with. There are many tensions between Aisha and Yusuf about Maha, who at 15 wants to go out with her friends and go to parties. Her father will not permit this. He also wants Maha to dress modestly, but she wants to dress like her friends. So this is the scenario, and you have watched the video as well. We will take a few minutes break so that you can absorb the information, take notes if you like, and prepare your questions. And we'll be back in a few minutes for the discussion. Thank you.
It would be recognized as a legal marriage here.
Okay, thank you. So the next question is, would Maha be able to get married legally in Canada?
So the answer to that is no. If a person is under the age of 16 or 16 or under, then they would need the consent of both parents, assuming that they have two parents. If they're 18 or over, then they can get legally married, but people under 16 cannot.
So what happens if someone still wants to get married at the age of 16? Or
well, at 16, if they have at the age of 16, if they have the parents' consent, assuming that there's two parents, and there are mechanisms in the law if you don't have two parents, or if you've withdrawn from parental care, etc. There's special circumstances, but if she's still living with her family and she's under 16, no, she could not.
Okay, thank you, Glenna. So the next question is, if Aisha wanted a divorce, could she apply for one?
Yes.
Okay, thank you. And the next question, where would she apply? That's the first part of the question. Yes.
Yeah. So if she lives in Ontario, she would be applying for her divorce in Ontario. I mean, I suppose if she wanted a religious divorce, I'm just speaking about the civil divorce, she would apply in Ontario.
Okay, so it's different in every province, right?
Yeah, you would apply in the jurisdiction in which you live. So if she's living in Ontario, she would apply in Ontario to the Superior Court.
Okay, the next part of the question is, what reason or reasons would she have to provide?
So in Ontario, we have, well, actually in Canada, this is federal law about divorce. Mm-hmm. There are 3 reasons that one can rely upon for divorce. One of them, which is the most common, is that the parties are separate and apart. And as long as a spouse is separate and apart for even a day, they can apply for a divorce. They cannot actually get the divorce unless they're apart for a year. So the divorce would not be finalized until that, if that's the ground upon which they're relying. They could also rely on the grounds of adultery or the ground of cruelty, which could be mental or physical. I typically don't see that very often. I sometimes see, as a strategy, I sometimes see I hate to say this just to generalize, but I do sometimes see men do that as a form of maybe emotional abuse. But generally, people usually rely upon the grant of separation.
Okay, thank you. So question number 5 was answered by Nusrat. So we can move on to the next slide, please. So I read the scenario.
Sitara and Glenda,
Yes.
just wanted to also add to the divorce in Canada, because in Canada we are doing under the Canadian law the Divorce Act. It's federally regulated. So is that like divorce is now like no fault? You can actually just is that the premise that we have? Like you don't have to be providing any other sort of reasons to get divorced, right?
Right. So that's why the first ground that I mentioned about being separate and apart, some people call that no fault. In other words, you don't have to give a reason, you're just separated.
Right. Okay, great. Thank you. So the next part of the questions are about marriage and polygamy. And the first question is polygamy legal in Canada?
So there is something in the criminal code that says that it is not legal.
So it's not legal.
Correct.
All right. The next question is, would Aisha lose any of her rights because Yusuf has married another woman?
So this is an interesting question because there's issue of rights and entitlement. So she would not lose her rights. It would be kind of complicated because it's possible that the other person, under some circumstances, could gain some rights, which would therefore possibly affect entitlements that Aisha would get. But that would be very, very complicated. And in this kind of situation, she should definitely speak with a lawyer, just to see, for example, if there was, spousal support and this Yusuf is married another woman and he has perhaps other children. It's possible, I don't know whether spousal support could be affected. So, I mean, this is a very complicated kind of question, but so there's not necessarily a yes or a no. She definitely would have to speak with a lawyer and see what the situation is in her circumstances. But technically, she should not lose her rights.
Okay, great. Thank you very much, Glenda, for your answers. And now Shanza is going to take care of the next part. Thank you.
Thank you, Glenda, and thank you, Sitara. So I will be talking about custody and child support. So this is the new information as part of this discussion. Since getting home, Yusuf has talked repeatedly about taking Maha to Malaysia to marry the son of his cousin. He says this would be very good for the financial situation of both families. As well, if Maha were married and living in Malaysia, they would not have to worry about her getting into trouble with boys in Canada. Aisha is opposed to this and is thinking about leaving Yusuf to protect Maha, but she wants to know what her rights and responsibilities would be and whether she would have enough money to support herself and the children. So regarding the custody questions, under Muslim family law, does either parent have an automatic right to custody or guardianship? And what factors play a role?
So would you like me to take this question? It's Nuzhat.
Yes, Nuzhat, please do.
Sure. So under most schools of thought, there are some provisions. Guardianship is restricted to the father. So the father is the guardian of the children. And custody is more like the care of the children. So the custody or the care of the children is the responsibility of the mother. And there is sort of an age provision. So the custody of the children for a boy is until the age of 7, and then the custody goes to the father. And for a girl, it's the age of 9. I think in one school of thought, there is a provision for the boy to remain in the custody of the mother until puberty, and for the girl until she marries. But on most instances, it's age 9 for girls and 7 for boys, where even the custody reverts to the father, and of course the guardianship and the responsibility to provide for the children, however, as the guardian remains with the father. So the major role of the father is to continue to provide financially for the children and in every other way, and for the mother to take care of the children until those ages I mentioned.
Thank you, Nuzhat. And we can go on to the next question. Does anybody want to say anything about what Nuzhat had said here so far? Okay. So we're going on to the next question. So under Canadian family law, how would a court decide who should get custody? Glenda, can you please talk about that? Okay.
So first of all, I just wanted to repeat the comment that I had sent everyone through the chat system, which is that the Divorce Act, which is being amended, the changes to the Divorce Act are going to be coming into effect in March of 2021. It was supposed to be July of 2020. So I just wanted people to know that the word custody, when it comes to the Divorce Act, is not going to be used starting next year. There's going to be terms about decision making and parenting time. So under the provincial law, the Children's Law Reform Act, which is for the non-divorce cases, so far the terms of custody and access are still being retained. It may be that the province also changes their legislation. I don't really know that yet. So that's just something that I just wanted to put out there at the outset. So at some point in time, we're not going to be using the word custody when it comes to new cases and new decisions starting 2020 under the Divorce Act. But in any event, when it comes to making decisions about custody or decision making, there is generally like a list of considerations that a court would consider about the best interests of a child. Now, because Maha is 15, her wishes, views and preferences are always considered by a court. But when it comes to a 15-year-old, that would have a very strong influence on a court. But generally, there are a whole basket list of considerations that a court considers when it comes to best interests of a child. I can send everybody what the content of that is under the, excuse me, under the chat.
That's great. Thank you, Glenda. And what would Aisha be able to do if Yusuf took Maha to Malaysia without her consent?
So this is very complicated. If she suspected that this was even going to be a possibility, if she came to me and I was her lawyer, I would be telling her some suggestions about what she should do before that even happened, because it's important if this kind of thing is suspected that a person takes steps before the child is removed from the jurisdiction. Every case is very specific about what I would suggest. It's possible she might want to go to court and try to get a non-removal order put in place. Those are not always that effective. She would want to, for sure, see what's going on with Maha's passport. It says in the fact scenario that Maha was born in Malaysia, so I don't really know what her citizenship is. She might have a passport from Malaysia. She might currently be a Canadian citizen as well. I don't know if she's a dual citizen, but these are all questions I would ask. It's possible that even if the mother had possession of the child's passport, there are some countries which allow one parent, usually it's the father, who gets the ability to, in some countries, get passports without the other person's consent or knowledge. I don't know about Malaysia, but I would definitely be urging her to check that. calling children's aid, because this could be, the issue of forced marriage could be a protection issue. Getting Maha to get some legal advice, possibly herself, because she's 15. There are a lot of publications that have been put out. I know there's a very good one that was put out by Salco about the issue of forced marriages. So I would want her connecting with resources and taking steps even before this happened or was contemplated. There are border alerts that can be put out as well. So those are preemptive steps I would take. If the child had actually been removed from the jurisdiction, that would be a very complicated scenario. Again, she should definitely speak with a lawyer who understands the issues of child abductions or removals from the jurisdiction. And because there's a lot of different things she might want to do. For example, if she put Youssef on notice and made demands to have the child come back, perhaps that could have some consequences to Maha, or, it's possible Youssef could hide her somewhere. It's possible she might want to be connecting with Maha directly to be seen what steps can be taken there. Maybe Maha should go to the embassy or the consulate, the Canadian consulate or embassy, to see if they can help her. So there might be some things that, she might want to liaise with Maha to do sort of secretly, if that's possible. So there's every situation is very different. Unfortunately, Malaysia is not a country that is a signatory to the Hague Convention on Child Abduction, like many other countries in the world. So that recourse would not be available if Maha was removed. So, contacting police, contacting RCMP, Canada Border Services, every case is a little bit different and should be evaluated on its own, depending on where the country is, the age of the child, and the risk. So there's no one answer for this issue, except for the fact that she should definitely be getting legal advice as soon as possible. And she should definitely be taking steps if this was even suspected before it even occurred.
I agree. And thank you so much, Glenda, for discussing on this question.
Yeah, I want to add also, there are a lot of publications put out. There's a very good one by the Canadian government about steps to take, considerations, etc. So if this kind of thing happens to one of your clients, you definitely want to send them, the brochures. In fact, everybody should be acquainted with what those brochures say, those Canadian guides, because they do have information about preemptive steps and who to contact. But they should also definitely go to a lawyer and get some legal advice. And the lawyer is should be a person who's familiar with these issues.
Can you please talk a little bit about the Hague Convention? I know that Malaysia is not a signatory, but what the implications are if Malaysia had been a signatory to the Hague Convention, and what Aisha could do then.
Okay, sure. So the Hague Convention is an international treaty to which many parties have signed on, including Ontario. And what this deals with is wrongful removals from Ontario, let's say, because we're speaking of Ontario, and wrongful retentions in another jurisdiction. So, for example, it would also deal with the situation where a child was in another jurisdiction with a time-limited consent, or with a consent that was not to be indefinite. It's not supposed to be a relocation, and the child was overheld. So it deals with those scenarios. It applies in regards to people that are of a certain age. So it would apply to Maha because she's 15. If Maha had been removed to a jurisdiction, which is also a signatory to the Hague Convention. And basically what it is if Aisha's child was removed to one of those jurisdictions, which is also a signatory, just like Ontario, she could get in touch with the Central Authority for Ontario. They would assist her by providing her with a filing package for the country to which the child had been removed or retained, Aisha could fill that out, and the Central Ontario Authority would send that to the other jurisdiction. Each jurisdiction treats these matters differently. They generally, the person like Aisha would have to get a lawyer in that jurisdiction. The Central Authority does not act as a lawyer for her and does not actually assign a lawyer for her. But the other jurisdiction could possibly assist her in getting legal aid if she's eligible, in helping her connect with resources there. The other jurisdiction, the Ontario and other jurisdiction, could possibly see if there's assistance they can give in trying to help mediate, to see if there can be a consent to have the child returned. That may or may not be appropriate in some cases. I mean, if there's some cases where the child could then be hidden somewhere or removed to another jurisdiction, that clearly would not be appropriate. Sometimes the left behind parent, which is the person that Aisha would be, the parent who remains in Ontario, might want to go to the Ontario court in some situations to get something called a chasing order, which is an order that basically says Ontario has jurisdiction over this child because the child was habitually resident in Ontario, and she could possibly ask for an order for the child's return. She could possibly ask for temporary custody, etc. But the problem is that order, the chasing order, is not necessarily, well, it's not enforceable in another jurisdiction. So sometimes the chasing order does assist, but sometimes it's not even necessary. So, if it's a Hague Convention country, there is reciprocity in terms of assisting for the return of a child who's wrongfully removed or retained. In addition, the test under the Hague jurisdiction is very different than what it would be under, for example, a custody case. So if there's a Hague Convention application, the country that is dealing with a Hague Convention application, so the country to which Maha had been removed, would not be deciding on custody. What they would be deciding on is there jurisdiction for them to deal with this case? Where was Maha habitually resident in Ontario at the time of the removal? Was there a wrongful removal? Is she, 15, so she would definitely be eligible, because of her age. So there would be possibly a presumption that the child should be returned. So the country would not be, or the jurisdiction would not be making a custody order. They could be making an order for the child's return to the jurisdiction from which she had been removed, such as Ontario. There are some defenses to Hague Convention applications. This is an entire program in and of itself, but there are some defenses to a Hague Convention application, but they're very limited. And really, for the parent who has removed the child, it is sort of an uphill battle to be able to successfully establish one of those defenses. So again, this is really highly complicated. And if this kind of thing happened and the child was removed to a jurisdiction, whether it's a signatory to the Hague Convention or not, this parent should definitely get some legal advice very quickly from a lawyer who knows what they're doing.
Thank you, Glenda, and thank you, Nuzet, for discussing the Hague Convention too, because international laws, especially in this kind of situation, would be really important to in regards to supporting the child and the parents who want to make sure that they make sure they protect the child. So anybody else wants to add anything to this? Then we can move on to the next slide.
I mean, this is Soraya here. A lot of times it might be just too expensive if they're going to get a lawyer back home, which they don't have the finances for. And it would, they might just not pursue it, That's the sad part, because not everyone has legal aid.
That is an issue, Soraya, and that's something that that we understand in regards to this. So I really hope, just like how Glenda has mentioned, that there are resources that are available. So if the parent who is concerned, and before even it occurs, it's really important, even if there's a suspicion or even if there's talk about this kind of situation, perhaps even Maha and Aisha can secretly, reach out safely and discuss that. So, some kind of support system can be built for them. So, again, like just like how you mentioned, like even if the legal aid is not available to them, at least they can start taking the steps in a very safe and secret way to really ensure that. Just like how Glenda mentioned, like preemptive steps to make sure that the child is protected, and what steps can be taken further legally, and and within the social context that within Ontario and Canada.
Thank you, Shanza. Yep.
Okay, thank you, Soraya. And Soraya, you can talk about property now.
Yeah. So, Nusrat, if you could help us out with this one. Under Muslim law, for family law, who would get the house? Nusrat, are you there?
Sorry, I forgot to unmute. So this is a complicated question. Under Muslim family law, either spouse, whether it's the woman or the man, who comes into the marriage with property or belongings or gifts that were given to them by their families, remains the property of the individual spouse. So, if a woman was given as a gift a house, it would remain her property. Everything she comes into the marriage with remains her property. Same with the man. If he comes in with a house and other gifts and money and whatever else, it remains his. It becomes a little complicated if she was given a house and that became their matrimonial home. So under Canadian law, maybe Glenda, you can shed some light on this. But essentially, under Muslim family law, it's not who would get the house. It's really what it's the possession. Who does all that property belong to? It would belong to the individual who came into the marriage with all of those belongings or properties and gifts. I will let Glenda explain what happens if that house that she received as a gift from her parent becomes a matrimonial home.
Thank you, Nusrat. Thank you.
Okay,
Glenda,
so
please elaborate. Yeah.
Okay, so under Ontario law, if the two parties are married, if at the time of separation, the two parties are living in the home as their matrimonial home, then that home would be considered as a matrimonial home. Now, of course, this applies to married people. And the definition of matrimonial home is as of the date of the separation. So regardless of the legal title to the home, regardless of whether it's owned by the husband or the wife or both of them, because your question here is a little bit vague. It says who would get the house. So the legal ownership still stays with the person who has the legal ownership. But the issue pertaining to the matrimonial home goes to the issue of possession of the matrimonial home. So who gets to live in the home. So regardless of who actually owns the home, if it's a matrimonial home at the time of separation, both parties, both spouses are equally entitled to possession of the matrimonial home. The other issue that is important about the matrimonial home is that if it's a matrimonial home at the date of separation, then if there's an issue about, some people think that the value of it is shared, so it's a little bit tricky. If the matrimonial home was owned by a party at the date of marriage, then normally, if it's an asset that's owned at the date of marriage, you get to count that as a deduction when the issue of net family property is being calculated. But if it's the matrimonial home, you do not get that as a deduction at the date of separation. So essentially, the value of that home is shared. So the question's a little bit vague, but so the important things are to consider the right of possession and whether there's a deduction. Now, if there is a matrimonial home and it's only owned by one person at the date of separation, in order to prevent possible, there's issues where, let's say, the husband owns the house and not the wife, or the wife owns the home and not the husband, so only one spouse is on title. Technically, in order to sell or get a mortgage or line of credit secured by the home, technically, if it's a matrimonial home, you need the consent of the other spouse. Now, there are people that do things improperly, such as sell things or get mortgages or lines of credit, secure the home without getting the consent of the other party and simply lie. They simply pretend that it's not a matrimonial home. So if the person is not on title to the home at the date of separation, or even before that, the person should be directed to a lawyer, a family lawyer, who could possibly direct them to a real estate lawyer who would be able to put a declaration on the title, which gives notice to third parties that this is in fact a matrimonial home. And that would prevent the person who's the titled owner from selling or transferring the home or encumbering the home with a mortgage or secured line of credit, etc. So, these are things that I would recommend, or I would canvass with the client if she came to me or he came to me with this kind of scenario.
Glenda, Sitara here. I have a couple of questions. What happens if the property is outside Canada? And the second part of the question is, what happens about the gifts that have been exchanged during the marriage?
So the matrimonial home, I'd have to look that up. I think it has to be in Ontario for it to be a matrimonial home, but I'm not 100% sure, so I don't want to guess. But if it's something that's a gift, a gift is a gift, right? So a gift belongs to the person that was given to.
Okay.
Again, I wouldn't just answer 100%. I would want to know the facts of the case, but there actually is law about gifts.
Okay, thank you.
And a lot of time talking about gifts, we've had clients that they're separating. Say they've separated. Now all the jewelry, for example, that was given to the girl, they want that back. Like, how does that translate into Canadian law? Would that be considered a gift to her by her? And I don't know. It's so hard for them to hold on to jewelry that was given to them by their in-laws at the time of marriage.
Is this a question for me?
Do you have an answer to that, Glenda?
Well, I do, and sadly, I see this issue a lot. Of course, the best thing for somebody to do in advance is for them to, before the separation even occurs, is for them to somehow try to take the jewelry and put it somewhere else, or find out about the safety deposit box, because sadly, this is a common scenario. And, what typically happens is, the woman says, okay, that's my jewelry. He has it. It's in the safety deposit box, or he's hidden it. The police are, they might be able to assist and try to get that back. But typically in 99% of the cases I see, the man denies it. He says, I don't have it. So, it's best to be preemptive about this and sort of, try to get the person to, take the jewelry, hide the jewelry herself in advance, put the jewelry in a safety deposit box that's only in her name, put it with a friend, get it out of the house. So technically, if it's a gift and it was hers, it technically does belong to her. Is she going to ever get that back, practically speaking? I rarely see that. I'm sure your situations are the same. I rarely see her get it back. Even if it does belong to her, I don't know.
Yeah.
You know, the other thing I tell people when they come to me as clients is, you know, your emotional attachment to that. I know it's difficult and it's yours, but you might have to come to the realization you might not get that
Might
back.
get it back.
You know, just try to see if they can focus on other things, their safety for sure, you know, their children, support issues, and, you know, and it's a very emotional issue though.
It is. It is.
Yeah.
So on the same note, is the mahar legally enforceable in Canada? Now this is what, yeah, go ahead.
Okay. So this is a question for me as well. Okay. So, basically under Ontario law, we consider that some documents that are entered into before marriage might comply with sections of the Family Law Act pertaining to domestic contracts. So there is a provision under the Family Law Act that deals with domestic contracts and deals with enforceability of them. Now, there's not a blanket answer to this. And when it comes to marriage contracts or domestic contracts that were entered outside of Ontario, such as the example in this case, there is a section, it's Section 58 of the Family Law Act, that deals with contracts that are entered outside of Ontario. And it says that a contract which is done by proper law, it says a contract of which the proper law is that of the jurisdiction other than Ontario is also valid and enforceable in Ontario if entered into in accordance with Ontario's internal law. So there's a whole checklist of what a court would look at to see whether it's an enforceable domestic contract. Witnesses, you know, whether it was in writing, etc. And there's also an overriding jurisdiction that a judge would have to set aside a domestic contract. So even if it's an enforceable and valid domestic contract, the Ontario court judge always has an overriding jurisdictional or judicial oversight to decide whether it should be set aside. So, for example, if there was a failure to disclose significant assets or debts or other liabilities existing when the contract was made, if a party did not understand the nature or consequences of the domestic contract, or otherwise in accordance with the law of contract. So there are other common law issues that a court could look at to set aside a domestic contract as well. It is, again, this is complicated, and the person should definitely go to a lawyer. Sometimes in these kinds of cases where the contract was made outside of Ontario, the court might need to hear from an expert as well to advise about the contract. In this particular scenario, I noticed that the wording talked about the deferral of the payment. So it's possible that, you know, I've seen cases where the deferral of the payment is ambiguous and uncertain, and a court has said, well, I'm sorry, that's not enforceable because there was uncertainty in this contract. So that would be, like I said, there's, you know, a court could decide not to enforce a domestic contract made whether inside or outside of Ontario, otherwise in accordance with the law of contract. So one of the things the court could consider is uncertainty. That would fall under that. So again, it's very complicated, and the person should definitely go to a lawyer and show the exact document and talk about the circumstances. And that's why when people sign domestic contracts in the first place, it's always good to get independent legal advice and to have it properly witnessed.
Perfect. Thank you so much for that extensive explanation. Really, that's wonderful to know. Okay, and now inheritance. This is new information. Neither Yusuf nor Aisha has a will. Yusuf dies suddenly at work. Aisha knows very little about the family's financial situation. She knows there's a lot of jewelry in a safe in Yusuf's home office, but she does not know the combination to get into it. She does not know where they bank, how much money is in their accounts, or how much money they owe on the house. Yusuf told her a few years ago, when his father died, that he had inherited several $100,000, but she does not know what he has done with this money. So, Nusrat, if we can lean on you, How does Muslim law treat this inheritance?
Okay, it's really complicated, but this is one of the areas of law that are detailed in the Quran quite specifically. So, it's verses 7 to 12 in Surah Al-Nisa. And it's actually way more complicated than one would think. So it talks about inheritance regimes that are relatively limited roles of bequests, which is limited by law to a maximum of 1/3 of the deceased estate, following payments of all debts, including delayed dowry, funeral expenses, etc. So after payments of all the debts and bequests have been made, the estate is divided in shares of 1/2. 1/4 and 1/8 and 2/3, 1/3 and 1/6 among a group of specific blood and marriage relatives, following detailed Quranic injunctions. In general, males will receive double the inheritance of females who are in the same category. So sons versus daughters. Sons will receive twice as much as the daughters. And female half share, this is a female half share rule. It's established in the Quran. It says, God instructs you concerning your children, for the male, what is equal to the share of 2 females. So this is very, very specific. Because of this unequivocal injunction, this rule has been difficult to reverse in Muslim law. But what happens in a lot of cases is that parents make a will before their death, and they can choose however they want to distribute their inheritance. Parents of daughters have generally found many ways to increase the share of for their daughters, either through bequests or establishing a trust and designating the daughters as beneficiaries. So another option might be to divide a portion of the parents' property among the children while they're still alive, as I said. And that this is done, it doesn't have to follow the half share rule. It can be whatever the parents want to do with it. So the rule does not mean that a daughter will inherit half of an uncle or a grandfather, for example. So it's really up to the parents before they die to protect what they want to give to their daughters, because if they don't have a will and they have not provided for awarding various shares to their children, then really it becomes way more complicated under family law, because it is prescribed in the Quran how the division should be done.
Correct. Wow.
Mm-hmm.
Yeah. So it really makes sense, I mean, that parents think of these things instead of leaving it to the children.
Yeah, and I mean, the reason why that provision exists in the Quran was that there was an assumption that daughters will get married and they will be provided for by their spouses.
Yes.
But of course, that does not necessarily apply here.
Yeah.
And there are many, doesn't matter which jurisdiction you're in, women, may not be provided for by their spouse, even though there's an obligation under family law for
Correct.
the husband to provide for the wife. Anyway, it's pretty specific in Muslim family law.
So Glenda, thank you so much, Nuzhat. Appreciate it. In Canada, what happens when someone dies without a will?
Okay, so first of all, the rules about this go by each jurisdiction. So I can speak about a little bit about Ontario as opposed to Canada in general, because each province or jurisdiction would have its own rules about this. Also, I have to be careful because I just practice in family law. I don't practice in this area of law. So my comments are going to be very general and basic. I would always, if a client came to me with this, I would always send them to a lawyer who does this kind of work. but I noticed that your publication from your association does have a little bit of information about this kind of scenario. I'm also going to send everyone through the chat feature a little bit of a link from the Ontario government that sort of expands upon the very basic information that I can tell you. So basically, in Ontario, I'm going to send that link to everybody right now. But in Ontario, if a person dies without a will, it's called intestacy, being intestate. And the Ontario Succession Law Reform Act would govern that kind of situation. So basically under that, if there is a person who is a spouse, if they're married, and there's something called a preferential share. So the first $200,000 of the estate would be given to that person if that person decided to claim that entitlement. There's a certain time limit for doing this as well, which is why it's really important to get someone to a lawyer. There's also an option for the person to elect to take half of the net family property that the person would be entitled to. So basically, you could choose, do you want to take this $200,000 preferential share, or do you want to take half of the net family property? Basically, it's considered as if the person died, as if the net family property is calculated right before the person's death. So a lawyer would be able to assist a client in figuring out which is the best option. If there is joint assets, though, for example, let's say there's a matrimonial home or some kind of property or bank accounts that are in the name of the two people as joint tenants, then the property would go to the other joint tenant, doesn't really go through the estate. It just automatically goes to the joint tenant. So that's treated a little bit differently. Anything over the $200,000 would be shared between the spouse and the descendants, such as children and grandchildren, according to specific rules. So it is a little bit complicated. This is not my area of law. I'm going to send everyone a very general link to what the Ontario government says. And again, this is an area where if you have a client who comes to you, you should send them off to a lawyer, an estates lawyer, maybe a family lawyer, but I mean, some family lawyers do both estates and family law. And of course, that would be ideal for this situation, but they should go to an estates lawyer.
Thank you, Glenda. Can we move on to the next question? I'm just being mindful of the time because there might be some other questions to be answered.
So would Yusuf's second wife have a legal right to claim a share of his estate? Glenda?
Sorry, let me just go back to that question.
Would Yusuf's second wife have a legal right to claim a share of his estate?
So I don't know if there's a yes or no answer that I could give. I mean, first of all, I don't think a family lawyer would be dealing with this kind of issue. It would go to an estates lawyer. So that would be the person to ask, a person who does that kind of work. I mean, it might also be dependent on whether that second wife knew whether Yusuf was married to somebody else at the time of marriage, or whether that person was duped and didn't know that she was a second or subsequent wife. But I don't really know a clear answer to that question.
Can I just say something? If she is considered a dependent because, they have been cohabitating, and maybe under, Canadian law, where maybe the common law relationship provisions would apply, she might be considered a dependent. So yeah, the best thing to do is to talk to a lawyer, but she herself, if she doesn't know that she's in fact a second wife and he already has a legal wife, because she would not really be recognized as a wife in Canada. But even as a common law partner, she still has to meet certain conditions of a common law relationship. And then whether or not she could prove that she was a dependent, that's another issue.
Thank you, Nuzat. Thank you.
Yes, Nuzat, thank you. And also, I think just like how Nuzat mentioned, that for Yusuf's second wife, just regarding the legal rights, if there is like a joint venture, there is something more about in case law, and if it could be proven, just what Nuzhat mentioned, then there could be things. But again, one needs to seek legal advice and provide more information into about the marriage and the claim of shares to the state based on the common law and how the marriage was legally done, and then if there is any property and how they were living and she was dependent on Yusuf, and so things like that. But again, like perhaps like a legal advice would be really helpful in that area, right? Thank you.
Thanks, Shanza. The next slide. And the final is, if Aisha takes the children and leaves Yusuf, can she get financial assistance from him?
So my answer to that is yes. She could definitely, for sure, there's an entitlement to child support. And in regards to the issue of spousal support from the fact scenario, it sounds like there would be an entitlement to spousal support as well. So the answer to that is yes.
Thanks a lot, Glenda. Thank you very much.
Okay, thank you, Glenda and Soraya. So I will be talking about the safety-related matters. And so although like the booklets and the documents that we have provided, they deal primarily with the issues of family law, it is important for women to know that criminal law provides some protection for abuse from abusive spouses. There are many forms of domestic violence that are against the law in Canada, including assault, sexual assault, forcible confinement, threatening, and criminal harassment, like stalking. Both restraining and protection orders and exclusive possession orders are important legal steps women can take through family court to protect themselves from abusive partners, especially during the early stages of separation, when risk of violence often increases. And application for a restraining order or for the exclusive possession of the home can be made as part of a larger family court proceeding dealing with custody, access, support, and or division of property, or it can be made separately. Another thing in regards to this, I also want to mention as well, is that women can call the police for help, but sometimes if it is not very much safe to do so, but if someone finds themselves to be in danger or in emergency, please do call 911. It does save lives. And just make sure that you have you're doing anything in regards to your safety. So that's just to make sure that you and your loved ones are protected and are safe. And you can do that secretly and safely to reach out and get the resources that you need. That could be part of your safety planning, but that's something that you just have to kind of do this maybe very discreetly and safely. And
I would like to mention.
Mhm.
No, go ahead.
Go ahead.
I just wanted to say that it's our duty to report if there's a case of child abuse or even a suspicion. So we need to call the Children's Aid Society of Toronto in the region where they are living, or call 911.
Yes, and thank you, Sitara. So there is definitely that, and also like if if you see any kind of abuse or witness that, just like how Sitara mentioned that, just call 911 just to make sure that the incident is reported, for the protection of the children and anyone who is in that violent situation or in danger. I would also like to mention briefly about the legal services coordination that is now on the slide. So the Canadian Council of Muslim Women, CCMW, is pleased to provide legal services coordination to assist the Canadian Muslim women in receiving legal services that are responsive to the needs, in regards to making sure that they're getting fair and equitable access to justice. It is a pilot project funded by the Law Foundation of Ontario that aims to formalize our ability to refer Canadian Muslim women to culturally appropriate legal services that address family law issues and protect them from violence. I would request Nuzat to kind of elaborate more about this.
Sure, thank you, Shanza. So the Legal Services Coordination Initiative is a 2-year pilot project that we have. We've already sort of started to use it. We have this page on our website that includes an intake form. So any woman who wants to apply to us can complete the intake form, and we will contact them to see what needs they have. They can also write to legalservices@ccmw.com. And there's also a phone number. It's all available on our website. So the purpose really is to monitor the content of the inquiries we get for legal services, as well as the access to justice. So can women actually access services that they are requiring? How successful are they? What are the gaps? So it's sort of a demonstration project, really, to help us understand what the issues are that Canadian Muslim women face in family law, how well they're addressed, and what the gaps are, so that those gaps could be addressed by government, service providers, and ourselves. And you'll see over the next few weeks, you'll see a campaign to promote this particular coordination initiative. And please do refer women to the website, and also provide the email address legalservices@ccmw.com. Legal services, all one word. We monitor this mailbox regularly, and we do get back to the women to help them navigate the system. Any questions?
Well, thank you, Nuzat. I'm sure this service is going to be very helpful to the Canadian Muslim woman, and I'm sure people are going to access this service. So can we go to the next slide, please? So we are going to continue with the questions. I see there are some more questions. So there's one question, says, would a second marriage that is not recognized in Canada be grounds for adultery? So Glenda.
Is that question directed to me?
Yes.
It probably would. I think it probably would. But again, from a practical level, if the client came to me and said that, yes, it would. But practically speaking, what do you want to do with that?
Okay, thank you. The next question is, how does a second wife get into Canada? Glenda, can you answer that question?
So if that question is from me, I actually don't know the answer. I think that that would be a question for an immigration lawyer.
So can I just briefly respond to that? It's Nuzhat again. What we know is that the men use very creative ways to bring in a second, third, or fourth wife into the country. Sometimes they sponsor them as caregivers. Sometimes they will falsely sponsor them as a relative. But you remember the famous Shafia case? In that instance, the second wife came in to be a caregiver to the family, and then of course she plotted the murder. So I think there are many ways they find this. The other thing that happens is in the country where the marriage may have taken place, if it took place outside of Canada, that marriage may have taken place. They may have documentation to prove that marriage exists. And again, they can cheat. They can hire an immigration lawyer and cheat to bring that woman in as their first spouse. But that would be very difficult to do. Most of the time, it's through this sort of, underhanded way of sponsoring them as a caregiver or some other means to get the woman into the country. Of course, that marriage, the second marriage, could also take place in Canada, but it wouldn't be recognized as a marriage because it's illegal to have more than one wife. Yet it does happen in Canada. And that person might have been brought into, the second person might have been brought into the country maybe as a caregiver. So that marriage could take place here, but it wouldn't be recognized under Canadian law because it's a second marriage, which is against the law.
Can I ask you a question? This is Glenda speaking. I often see when they have a subsequent marriage that they just do the religious ceremony for the subsequent spouse, the subsequent wife, and not necessarily the civil marriage. So maybe can you just add some comments about that?
So our position, CCMW position, is that is illegal because under Canadian law, under the criminal code, more than one marriage is against the law. The men who perform these marriages are, again, being very clever and recommending that the marriage not be registered because they wouldn't be able to register it anyway, because there's a first wife registered already. So they do this, and this is, Glenda, this is an issue that seems to be occurring more and more, where an imam will perform that second, third, or fourth marriage, will not register it, and the man will declare, well, I have an Islamic marriage, so I'm legal, not legally, but Islamically married. And there's a lot of debate about this issue, and it's one that CCMW is actively pursuing. Our main concern is what happens to the women in these situations, whether it's a first, second, third, or fourth wife, and also the children. What are the impacts? What are the socioeconomic impacts of marriages like these? Because in the end, we should be really thinking about the protection of the women and children, because the men will do what they're doing. There's been no prosecution. As you know, there have been some legal precedents. And there is a case that was ruled on by the Supreme Court, where the decision was made really based on harm and abuse of the subsequent or the multiple marriages on women and children. But it's still a disputed area. There's a lot of debate and discussion within Muslim communities, but CCMW is pursuing this issue actively.
Okay, thank you, Nazat. So unless someone has any other comments, any questions, you can unmute yourself, give your feedback. If you like, any other questions? So, okay, with this, we are going to conclude today's webinar. We have covered 6 areas of family law: marriage, divorce, custody and child support, family property and spousal support, domestic contracts, and inheritance. I would like to thank everyone for participating in the discussion and making it very interactive. The questions were very interesting. I would also like to thank Glenda, who answered some very critical questions about Canadian family laws. And thank you, Nazat, for participating in the discussion, answering questions, and for your feedback. And I'm very excited about our next project. And a big thank you to Soraya and Shanza. I'm so impressed with your commitment and dedication. And not to forget Sabrina and Zainab for their technical assistance. So if you sorry?
Oh, this is Glenda speaking. I just wanted to apologize for that little glitch in my technology. And I wanted to thank everyone for attending this, especially CCMW for their advocacy and for organizing these programs and creating these materials. I think it's invaluable, especially for lawyers like me who deal with people in your community. And I really want to thank you for all the hard work that you do.
Thank you,
Glenda. Thank you.
This is very encouraging.
Thank you, Glenda.
It's very useful. If you like further information and clarification, please see the comparative primer and the 6 brochures that are available on our website, www.ccmw.com. And please don't forget to share the information with your networks. Also, please complete the evaluation form. It takes only a few minutes to complete the form, and you don't need to write your names. This is confidential and will only be accessed by CCMW staff. The link is in the chat box actually, and will also be mailed to you later on. And thank you again, and please stay tuned for our upcoming webinars. Thank you.
Before everyone goes, I just want to say thank you to the Niagara and the Brampton-Mississauga chapter, Surya, Shanza, Sitara, and of course our amazing team of Zainab and Sabrine. You guys are pretty amazing, and thank you, Glenda, for being part of this. We really appreciate it. Thanks,
you.
everyone.
Right.